Thank you, Johanna. Hi, everybody. Should we wait a few minutes or should we go ahead and start? I think we're 2 minutes over time. Maybe wait just 2 minutes to see if anybody else trickles in, and then we can start. Is that okay with you, Attorney General?
Yeah, no problem. It's all right.
Okay, thanks so much. Okay, hello everybody. I think we're 5 minutes beyond 3, so maybe we go ahead and start. So welcome and thank you so much for joining today for this session about children's rights in the ICJ process. My name is Ben Wildfire. I'm Child Protection Specialist from UNICEF Pacific. Without further ado, I'll hand it over to the Attorney General of Vanuatu, Arnold Kiel Loughman, to make some opening remarks. Thank you so much for being with us today. AG, over to you.
Thank you, Ben. Thank you, everyone, for this opportunity. But for our opening remarks, ladies and gentlemen, esteemed participants and distinguished guests, I'm honored to welcome you all to this important webinar on children's rights in the context of the ICJ Advisory Opinion on climate change. At the outset, I would like to thank the SPC for its continued support to the Pacific Island states in the preparation of robust national submissions and through their own submission on behalf of SPC. This second online webinar aims to delve into the convergence of climate change and children's rights, underscoring the pressing need to prioritize the unique vulnerabilities and rights of children in our legal submissions. Climate change represents a direct and disproportionate threat to the well-being of our children, particularly in the Pacific region, given our vulnerability of our islands. Today, let us collectively engage in a meaningful exploration of how we can address these challenges at the International Court of Justice and place the welfare and rights of our children at the forefront of our climate justice efforts. there are existing legal obligations for us to submit strong legal arguments to the court. In the internationally binding Paris Agreement of 2015, nations committed to upholding human rights, particularly the rights of children, as an integral part of addressing climate change. The Human Rights Council resolutions underscore the significance of a safe climate for the well-being of all, with a special focus on the rights of marginalized and disadvantaged children who face heightened risk. General Comment 26 by the Committee on the Rights of the Child mentions clearly states are accountable not only for environmental harm within their borders, but also for the global repercussions of such harm on children. The principle of intergenerational equity underscores states' responsibility for foreseeable environmental threats resulting from their actions or inactions. Children, despite being the least responsible for the climate crisis, bear a disproportionate burden. The interconnected nature of their rights means that virtually all aspects of their well-being are at risk due to climate change, impacting the effective implementation of the Convention on the Rights of the Child, which 196 countries are party to, including every member of the United Nations except the United States. The specific impacts experienced by children and violation of their rights within our own nations are also important to be shared in our submissions to acknowledge that climate change is not confined by borders. Children, particularly the most disadvantaged and marginalized, face multifaceted and compounded impacts on their rights. From compromised access to essential services such as education and healthcare, to the exacerbation of existing inequalities, to loss of traditional knowledge and culture. Now, let me share with you a quick example from Vanuatu. In the aftermath of twin cyclones in March of this year, 2023, schools were closed, disrupting children's access to education for over a month. Among the 1,387 schools spanning the 6 provinces, 328 reported minor damage, while 279 suffered major damage to classrooms. Homeschooling was considered, but then impeded by factors such as power outages, inadequate support structures in schools for remote learning, a lack of shelters and home environments that were unsuitable for post-cyclone learning, thereby limiting parental support for children's education. We will be joined today by esteemed experts from UNICEF, the law firm Course, and representative of the civil society who will share their insights on the implications of the ICJ Advisory Opinion on children's rights. I look forward to hearing more from the panelists today, and thank you all for your time and commitment to ensuring that the rights of children are considered and hopefully argued in the legal submissions that go before ICJ from our region. Thank you, Thomas, and welcome. Thank you.
Thank you, Tomas. Thank you, Attorney General. Yeah, thanks so much for those inspiring words. We really thank and congratulate the government of Vanuatu for its leadership during the whole process. That you and your colleagues there have done so much to kind of push this forward. And putting my UNICEF hat on, it's so great to hear you talk about where children's rights can fit in the broader process, and hearing the specific example of how climate change is impacting children's right to education, you know, one of the most fundamental rights that they have in Vanuatu. For the next 90 or so minutes, we're going to zoom in on this specific kind of topic and that very issue, how children and young people and a focus on children's rights can be an important part of the broader ICJ process. I think for UNICEF that it's clear to us that children's rights are at the heart of climate change. And as the Attorney General said, children have done the least to contribute to the problem and will suffer the most from its consequences. In the ICJ process in the Pacific, UNICEF has tried to put children and young people at the center as well through two primary ways. So the first is by taking the lead from organizations like Pacific Island Students Fighting Climate Change, and it's great to have Michelle here, and he'll talk a bit later, but taking their lead and giving children the platform to influence the content and the nature of the process and of state submissions to the ICJ. I mean, this is basically just listening to children who have been telling adults, governments, anyone who will listen for years in the Pacific and across the world more broadly, that we need to do more to address this problem. There have been some great examples from across the region of doing this to contribute in this specific process. So for example, in Vanuatu again, recently there was a children's forum organized by Save the Children and UNICEF, where youth had the chance to offer testimonials about how climate change is impacting their lives that can eventually be annexed to a state submission. I understand there's a similar event that's going to happen in Kiribati later this week, where UNICEF's working with the government to, give children another forum to tell those responsible for drafting Kiribati's ICJ submission what areas they think should be included, highlighted, and emphasized. For UNICEF, beyond listening to children and supporting them to participate in the process in a meaningful way, the second area that we've really prioritized is underlining how legal arguments related to children's rights can be included in ICJ submissions themselves. So this is looking at the Convention on the Rights of the Child, the new general comment on children's rights with respect to the environment and beyond. So towards this end, I'm very happy to introduce our next presenters, Nastasia Sudonik and Phoebe Wynne Pope from CORE's Chambers Westgarth. And I think Dr. John Tobin might say a bit here as well. Under an agreement with UNICEF Australia, CORES has produced a legal briefing on the obligations of states to present and future generations of children. This briefing will be made available to anybody who would like to use it. But for now, I'll hand it over to Nastasia and Phoebe to walk us through some of the key points. Nastasia, would you like to share your screen, or I think Johanna might be able to do it also with the slides, and Phoebe?
Either way, whatever is easiest. What do you think, Phoebe? Should we control or? Yeah, we can control. It'll just take a little minute.
Okay, great. Thanks.
Might be easier. Okay. Just sharing now. Hopefully the technology will work. I think. Here we go. I think that's working. Is that right?
Yes, we can see your screen now.
All right, great. All right, well, we'll launch right in. Thank you very much, Ben, and thank you very much, Attorney General. I'd like to reiterate Ben's comments that Vanuatu has really taken such a leading role in the world in respect of the encouraging the International Court of Justice to issue an advisory opinion on this very important matter. My name is Phoebe Wynne Pope. I'm the Head of Responsible Business and ESG at CORES, and I'm joined here with Nastasia Suhodolnik, who's a partner in and one of our leading public and international law experts. I'd like to start, as we do in Australia, in acknowledgement of country. Nastasia and I join you today from the unceded lands of the Wurundjeri people, and we pay our respects to their elders past, present and emerging. And when making acknowledgement of country, particularly in the context of climate change discussions, I'm mindful that Aboriginal and Torres Strait Islander people have held custodianship of these lands for more than 60,000 years with very little impact on the environment. a poignant thought for us all today as we discuss states' obligations in respect of harms to the climate. As many of you will know, and as Ben just told us, UNICEF has asked us to prepare a legal memo that would identify the obligations of states to protect children of the present and future generations from the adverse impacts of climate change. And the memo has been prepared by a team here at Cause Chambers Westgarth and with assistance from Professor John Tobin at Melbourne Law School, who's here with us today and will speak on the panel later. And we also thank Zoe May, a PhD candidate from Melbourne Law School and a research fellow at Melbourne Climate Futures, who's also with us today, and thank her for her significant contribution to the memo. The memo addresses the questions referred to the ICJ from the perspective of children and has been prepared to assist states and in particular the states of the Pacific as you develop your submissions to the ICJ. It addresses the questions in three parts. Part A of the memo explains why the ICJ should have particular regard to children when answering the questions before it. Part B discusses the substantive obligations of states in respect of children's rights impacted by climate change, including considerations of both international, environmental and human rights law. And in Part C, the memo discusses the legal consequences for states that breach the obligations identified earlier in the memo. What we thought we'd do today is take you through the key points discussed in the memo, and we'll focus on states' substantive obligations to protect current and future generations of children. And we'll only briefly touch on the legal consequences for breaches of these obligations. They are in the memo, but we ran out of time, or I think we'll run out of time today. But first, there are some fundamental elements that we wanted to discuss with you, which form the foundation of the memo. Nastasia.
Hi, Phoebe and Nastasia. Sorry, I think your presentation is frozen. I don't think it's only for me. It's stuck on the first slide. So maybe try to reshare your screen.
I don't know if it's me or Johanna's sharing at the moment. Is it?
So I think,
yeah, you guys are frozen. I'm going to just share.
Yeah, thanks.
Right. Okay.
Thank you thanks very much
Thank
for
you.
that. There is no presentation without a technical issue. So it's good to be staying true to the technical difficulties of modern time. We are just on slide 5. It's actually not 5, but the one before.
Number 4.
Yeah, number 4. There
That
we
one.
go.
Thank you.
That's where we are.
Thanks, Johanna.
Thank you very much. So one important point to note as we delve in is that in August this year, as you will know, and has been mentioned, the Committee on the Rights of the Child, or we'll refer to it as the CRC Committee, released a very important general comment number 26, on children's rights and the environment with a particular focus on climate change. And this general comment has been a very useful source in our analysis, and we'll keep referring to it throughout the presentation, and you'll see it referred to in the memo. At the same time, though, in addressing the legal obligations of states in respect of children and climate change, we need to test the various statements in the general comment against established norms under international law, and we have to distill from it what's binding as an obligation of states in respect of children, which is what the ICJ is asked to opine on. And so that's what we did in our memo in 2 steps. We first identified rights that are most threatened by the impacts of climate change. And here we focus only on the rights under the Convention on the Rights of the Child, or the CRC. Although this isn't to say that children don't enjoy rights protected under other human rights conventions and under general international law, and the CRC Committee did recognize that all rights are threatened in one way or another by the adverse impacts of climate change. So that's the first step, identifying rights. The second step in our analysis is to identify obligations, considering the scope of states' obligations in respect of those rights. And one important point to bear in mind in the drafting process is that it's possible for the rights of certain people to be impacted without corresponding breaches of states' obligations. For example, not every loss of life is attributable to a breach of a state's obligation to implement protective measures that safeguard life. And whilst climate science is clear and many of the impacts on the rights of children are well established and documented, it's still necessary to establish that those impacts are linked to either a state's action or a state's failure to act within certain parameters in order to establish responsibility for human rights harms. And in this memo, you'll see that we've been quite clear to identify where rights may be impaired and then draw from existing jurisprudence and from expert opinion, including the Human Rights Committee and the CRC Committee, to identify the state's obligations in such circumstances. And we'll move on to the next slide now.
Thank you, Johanna. I'm going to scoot through a few issues so we get to the substantive obligations, but these issues are important to set the frame of the advice that we have prepared. The first issue addressed by the memo is why the ICJ must have particular regard to children when considering the request. And in short, while we acknowledge that the request doesn't directly reference children or the Convention on the Rights of the Child, the CRC, it is incumbent on the ICJ, as it discharges its function, to consider all international law, including the obligations of states in respect of children. And we've been reminded today that the CRC is the most ratified convention, human rights convention. So if we could, the memorandum then goes into some detail about how climate change is impacting children and interfering with their rights. And again, I don't think we need to go into this detail here, as I'm sure those impacts are felt by many of you keenly, although there is a clear acknowledgement in the evidence and the memo that children, and especially in the Pacific, are particularly vulnerable and disproportionately affected by the environmental impacts of climate change. We then will go to the next slide, please, Johanna, and we turn to substantive issues, and the analysis starts with the best interests principle. This is a fundamental and overarching principle found at Article 3 of the CRC, and it frames the obligations under the Convention. The best interest principle demands that in all actions concerning children, the best interests of the child shall be a primary consideration, including in the adoption and implementation of environmental decisions, whether they be laws, regulations, policies, standards, guidelines, plans, strategies, budgets, international agreements, and even in the provision of development assistance. And this was acknowledged clearly by the CRC committee in its general comment. While the obligation to consider the best interests of children does not mean that children's best interests are the first or the most important consideration, the CRC committee has clearly stated that where there are potential conflicts of interests, there should be a careful balancing of those interests. An appropriate weight should be given to the primacy of the best interests of the child, and a larger weight must be attached to what serves the child best. Where a decision is made that doesn't meet the best interests of the child, the grounds for that decision should be set out by the state in order to show that the child's best interests were a primary consideration despite the result. Displacement of best interest by the child by a state's action will only be justified when a state can demonstrate that there is a lawful basis for interfering with the right, that the interference is necessary to achieve a legitimate aim or a pressing social need, and that the measures taken in order to achieve that aim are proportionate. The balancing of conflicting interests is one of the most complex issues, and we'll come back to it later in our presentation.
So if we move on to the next slide, we get into the actual obligations in respect of children's rights. And that's the middle section of our memo. It discusses the obligations of states to protect current and future generations of children. And we do this by considering obligations, like Phoebe said, under international human rights law and international environmental law, which are intertwined in many respects, as we'll talk about later on. Now, in this section, we first look at the territorial scope of states' obligations under the CRC. And in particular, we look at circumstances when states owe obligations to children beyond their national territories, a very important issue for the Pacific. We then move on to discussing the specific rights that are most severely impacted by climate change and the associated obligations of states to protect those rights. And finally, we address, and I come back to what Phoebe just mentioned, the question of balancing of competing interests and rights. And this is particularly important given the common refrain, as you all have heard, that most of these rights are progressive or subject to available resources and competing priorities, of which there are many. And we'll consider this in the context of climate change. And we'll think about when states will be in breach of their obligations by failing to direct adequate resources to climate change adaptation and mitigation to protect children's rights. But firstly, the territorial scope of application under the CRC. The CRC obligations apply in respect of children within a state's jurisdiction. So the first question to answer is what's meant by jurisdiction. The ICJ has been very clear that in the context of human rights treaties, jurisdiction is not limited to a state's national territory or its nationals within national territory. It's to be interpreted more broadly and encompasses the relationship of authority and effective control between an individual and the state, even if that individual is outside of the state's national territory. And this concept has been accepted by a number of courts and human rights bodies, including the Inter-American Court of Human Rights, the European Court of Human Rights, the Human Rights Committee, and the CRC Committee. Now, the test to determine if a state could be legally responsible for human rights harms, including to children, outside of its national territory resulting from climate change is on the slide. I won't go through it in detail, but I will say that you'll see states might argue to the contrary, but we think that there is a good argument under international law that states do owe human rights obligations under the CRC to children, both within and outside of their national territories, where it's reasonably foreseeable that emissions originating from within their national territory that are within their effective control contribute to climate change and present a threat to the rights of children, whether they be within or outside of their national territories. Now, moving on to the next slide, building on the recognition that states owe obligations to children at home and abroad, we next consider what rights are engaged and what states' obligations are in respect of those rights. And we first look at some general obligations under the CRC. Put at its highest, the CRC requires states to respect and ensure the rights set forth in the Convention to each child within their jurisdiction. Now, what does that mean? This general obligation involves both negative and positive duties. In terms of negative duties, states must take all reasonable measures to refrain from violating the rights in the CRC. Negative duty. Then separately, states have positive duties to ensure children's rights. And this includes an obligation to take all reasonable measures to protect children's rights against any unreasonable interference by third parties, including emissions-generating businesses, and also, even more broadly, an obligation to fulfill children's rights, which requires states to take all reasonable measures to facilitate children's enjoyment of their rights. We'll go into what all of these terms mean in a little bit, but there's another general obligation, which is an overarching implementation obligation under Article 4 of the CRC, and that requires states to undertake all appropriate legislative, administrative, and other measures for the implementation of the rights recognized in the Convention. And in the context of economic, social, and cultural rights, these implementing measures must be undertaken to the maximum extent of states' available resources and within a framework of international cooperation. Now, it's important to note that these general obligations are qualified by reference to what's appropriate in the circumstances and states' available resources. And states have a margin of appreciation in determining what measures are appropriate and what's the maximum extent of their resources. However, this discretion isn't unlimited, and we'll come back to this later. But for now, I would just like to underscore that contrary to what some states are expected to argue, this progressive nature of the obligation to implement rights under Article 4 doesn't mean that compliance is self-judging. Article 4 does impose an obligation on states to move as expeditiously and effectively as possible towards full realization of rights, and they have to demonstrate that every effort has been made to use all available resources to satisfy, as a matter of priority, the rights of children under the CRC. And those are very concrete obligations. And what this means in the context of climate change was highlighted in the General Comment number 26 by the CRC Committee, where the CRC Committee was quite specific. It said that to respect, protect, and fulfill children's rights, states must ensure a clean, healthy, and sustainable environment. So staying with the CRC General Comment number 26, here on the slide, you can see that the CRC Committee identified several rights as being at greater risk of impairment because of climate change, and they're listed here. Our memo focuses on a subset of these rights that, in our view, are particularly important to highlight, and they're bold on this slide. We won't have time to go through all of them in detail, but I would like to look at the right to life, survival, and development in Article 6 of the CRC, just by way of a case study to show you how we went about our analysis to identify rights and associated obligations. So if we move on to the next slide, under each right, we identify the scope of the right, the impact of climate change, and associated obligations of states. Looking at the right to life, starting with impact, the CRC Committee has been very clear in the General Comment. It recognized that the right to life is threatened by environmental degradation, including climate change, and that environmental degradation jeopardizes children's ability to achieve their full development potential. Now, recognizing that impact, what does the CRC require states to do in relation to climate change is the very important question. Firstly, and that goes back to our discussion of general obligations, states have an obligation to refrain from taking action that exacerbates the impact of climate change, and that's the negative duty. Like I said, states also have positive duties, and in terms of positive obligations, states must take all necessary, appropriate, and reasonable measures within available resources to address the conditions in society that may give rise to direct threats to life. And that might include protection against climate change-related harms by third parties, including by business enterprises. And finally, states must also review legislation, policies, programs, and other measures that risk interfering with children's rights by harming the climate system or other parts of the environment, so as to satisfy themselves that lives of children are adequately protected. Now, this obligation to take appropriate positive measures is very important in the climate change context. The European Court of Human Rights explained that for a state to be in violation of its obligation to take preventative positive measures, the authorities must or ought to have known of a real and immediate risk to life and fail to take measures within their powers to avoid that risk. If that reasoning is followed in the context of climate change and children's rights, it could be said that knowledge of climate change risks to children, as supported by growing scientific evidence, will trigger the obligation to take preventative measures now to protect children against threats to life from climate change. And a failure to take such adequate measures in a timely manner will contravene Article 6 of the CRC. We step through this sort of an analysis in respect of all of the other key rights that we highlight, including the right to the highest attainable standard of health, which we invite you to have a look at under Part B of our memo. We move on to the next slide. I'll hand over to Phoebe.
Thank you, Anastasia. So here we discuss a little bit the balancing and competing obligations and the principle of proportionality. So when we're thinking about addressing climate change, it will often require the reallocation of resources within a state and be accompanied by a range of transition costs. This raises the potential of conflicting rights and interests, not only within and between communities, but also intergenerationally. We talked earlier about states having a measure of discretion when weighing up different competing interests and rights, and the need to balance or to prioritise resource allocation, which may impact on different rights holders differently. However, it's important to note that under international law, this discretion is limited, and as Anastasia noted earlier, this discretion is limited by the obligations states have, and amongst those obligations, those under the Convention. So that the CRC committee hasn't really provided any guidance as to what a reasonable balance might look like. But the Committee on Economic, Social and Cultural Rights has outlined some guidance that can be applied by analogy, and the factors identified by that committee are included on this slide. Along with a reasonable balance, the principle of proportionality, which is a well-known principle under international human rights law, also forms the assessment of whether a state's failure to take appropriate measures to address climate change contravenes its obligations. In summary, the principle says that if a state wishes to adopt measures that are not in the best interest of the child, in pursuit of another interest or right, then this will only be justified if the state can demonstrate that the measures taken were proportionate to the level of foreseeable harm caused to children. The greater the scale and severity of the impact of climate change on current and future generations of children, the greater the burden on a state to justify its failure to take measures to address climate change, even when this failure is due to efforts to protect other legitimate interests. If we could move to the next slide, please, Johanna, thank you. These principles were brought into sharp focus in what's known as the Billy case, a complaint by several Torres Strait Islanders against Australia before the Human Rights Committee. The decision of the committee is particularly insightful on how states should strike a reasonable balance between competing interests and when a state will contravene human rights obligations by failing to adopt mitigation and adaptation measures. In this case, the Human Rights Committee considered Australia's positive obligations to protect rights holders from the Torres Strait against human rights violations caused by climate change, including the rights to life, culture, and private life, family, and home. The Australian government sought to limit the scope of its positive obligations under the ICCPR based on limited resources available to protect rights holders in the Torres Strait compared to other priorities. The Human Rights Committee rejected this argument in respect of cultural rights and the right to private life, family and home. The committee concluded that Australia breached its positive obligations by failing to adopt timely and adequate climate adaptation measures to protect those rights. However, in respect to the right to life, the committee found no breach, as it considered there was still sufficient time for adaptive measures to be effective to protect the right to life. The committee further concluded that robust national and international efforts are required to prevent several Torres Strait Islands from becoming uninhabitable as a result of sea level rise, and in the absence of such efforts, climate change may expose individuals to a violation of their right to life in the future. This finding supports the view that limited availability of resources will not be a complete defence, and states will need to explain their policy choices and priorities having regard to the principles of reasonableness and proportionality. I'm going to hand over to Anastasia to speak to the obligations under environment law.
Thanks very much, Phoebe. And I realize that we're running out of time, so I'll be very quick now. The memo also addresses states' obligations under international environmental law, like I said before. We won't have time to deal with each one of these principles you see on the slide, but I would like to emphasize the relationship between these obligations and human rights obligations, which is sort of a novel concept. There's a growing recognition that human rights and international environmental law obligations are mutually reinforcing. And the Human Rights Committee, for example, has explicitly stated that the obligation to protect and ensure the right to life depends on measures taken by states to preserve the environment and to protect it against harm from climate change caused by both public and private actors. Now, there's a number of very well established international environmental law principles that bear on obligations of states in respect of children. And the most important ones to mention today are the obligation to prevent significant transboundary harm and the precautionary principle. Both of these require states to exercise a level of due diligence when activities within their territories risk harming the environment, which includes humans and children, both domestically and internationally. To discharge this due diligence obligation, as you all will have heard, states must undertake an environmental impact assessment before authorizing harm-inducing activities. And this assessment has to be done in respect of anticipated environmental impacts and, very importantly, in respect of harm to children. And the CRC committee expressly acknowledged the need to undertake child's rights impact assessments in its General Comment 26. And when a state fails to undertake the appropriate due diligence, including by way of an impact assessment, it's unlikely to be able to demonstrate that it's considered the best interests of the child and fulfilled obligations under Article 3 of the CRC, a very important principle to take away from today. Now, the memo also discusses the duty to cooperate, the principle of solidarity, and the principle of common but differentiated responsibilities and respective capabilities. Very important principles for developing states. Both general international law and Article 4 of the CRC require states to take action through international cooperation to respect, protect, and fulfill children's rights. And while this obligation of international cooperation does not compel international assistance to be provided by developed states through international cooperation, it does require states with available resources to justify their failure to provide assistance as being reasonable in all circumstances. We go back to the principle of reasonableness Phoebe discussed earlier. And failing such justification, there may be a breach of duties to cooperate in Article 4 of the CRC. And this construction of the obligation is also consistent with the principle of common but differentiated responsibilities and respective capabilities. And again, I'm sure you will know that this requires states with greater capabilities to take more ambitious climate change mitigation and adaptation measures. And that also applies to ensuring children's rights. Those measures need to be taken to ensure the rights of children within their jurisdiction, so domestically and extraterritorially, and also not to interfere with the ability of developing states to respect and ensure the rights of children within their jurisdiction. I'll stop here on environmental law principles, and I'll just very briefly, if you move on to the next slide, deal with state responsibility, and we'll I'm sure be able to answer any questions as we move on to the panel. But to cover the law of state responsibility, we've set out some principles in Part C of the memo. And these are all very well established principles, so we don't propose to focus on them today. Just to note very briefly, the states that breach their obligations to children, for those states, the consequence is, as with all breaches of international legal obligations, international responsibility and an obligation to provide an appropriate form of remedy both to the injured state and to the injured children. The one thing to emphasize in respect of children is the right to an effective remedy. For children impacted by climate change, this could take many different forms, but in essence, the procedural right to remedy requires states to provide access to justice and to address the wrong committed by securing redress and, where appropriate, by providing a form of compensation. And final point to note, the CRC committee in its general comment 26 was very clear in acknowledging that states must establish both non-judicial and judicial mechanisms to provide access to effective remedies for abuses of children's rights, including for abuses by business enterprises. We'll finish on this point and, of course, invite any questions, and we'd be very happy to answer questions offline as well. Thanks, Ben, and thanks, Joanna.
Thank you. Thank you so much, Phoebe and Nastasha, for laying out the very specific ways that states and others can use the CRC and broader arguments from international law related to children's rights to strengthen, their submissions. As I said before, there's a detailed briefing which can be shared after the webinar for anybody that is interested in using it. But at this point, I would stop and see if there's anybody who has any questions for the CORS team on the presentation. If you do, feel free to raise your hand or put it in the chat. Thanks. Just wait a minute. Otherwise, if there's no questions at this point, we can move on to the panel, and then there'll be an opportunity for any questions after that as well. A last call. Yeah, there's a Q&A function also, Joanna says. So there's a lot of ways that you can ask questions if you want to. Okay, well, think about it while we're on the panel. If anybody has a question, you can come in at that point, and Phoebe and Nastasha will be available to answer them also. Our panel now is going to include Vishal Prasad, the campaign director for Pacific Island Students Fighting Climate Change. The AG, Arnold Kiel Loughman, Attorney General of Vanuatu, Professor John Tobin, Professor in International Human Rights Law at the University of Melbourne, and Gabrielle McMahon, Human Rights and Social Inclusion Advisor for SPC. So if everybody who's on the panel can turn your video on, and maybe Johanna or another co-host can help to pin the videos. Okay, I think we can go ahead and dive right in. The first question is for Vishal. And I can't see, I saw him earlier. Yeah, there's Vishal. Hi, Vishal. I hope you enjoyed COP. Very busy man. Vishal, I was wondering if you could explain a bit the background of the campaign that you and the Pacific Island students have led to ask for the ICJ Advisory Opinion, and how you think children and young people are able to have done and can continue to influence the process. Kind of getting at that first point I was making in the beginning about having young people take the lead and having their voices heard. So over to you, Vishal. Thanks for joining.
Thanks, Ben. Pulavinak, everyone. Good afternoon. If you can hear me. Good to be here. Thank you for organizing this webinar and for inviting us as well. Very happy to speak about this. Maybe, as Ben said, to maybe start with a bit of background and information about how the whole campaign began and how this idea for an advisory opinion has reached a stage where we are right now. We're talking about specific thematic areas such as children's rights and how these are so important for the ICJ to consider. From the very beginning, this was an idea for the ICJ to issue an advisory opinion. It was always an idea by young people, which began at the University of the South Pacific. Many you would know about this, many of you would know about this for some time now. And something that was interesting for the 27 law students that began this campaign was a focus on human rights and intergenerational equity. And these have been mentioned quite extensively in today's presentation. So one of the first formulations of the legal question that we had thought about, or that was put forward early in 2019 as part of our campaign brief, was again asking what are the obligations of states and the international law to protect protect present and future generations from the adverse effects of climate change. And so from the very first instance, or from the get-go, it was about human rights and intergenerational equity, and the focus has remained. And I think children, young people, we have campaigned throughout that from the beginning until the UN General Assembly resolution to ensure that these remain central to the ICJ resolution that was adopted, and also central to the ICJ's opinion that will be issued later on. And so the final resolution that was achieved that was adopted by the UN General Assembly again makes a very strong case for the inclusion of these elements. And I think young people have been a strong part in pushing this through, and are continuing to push forward for a stronger position on these themes going forward as well. The idea of intergenerational equity was also something we had drafted in what we call the Youth Climate Justice Handbook. So this was one of the first publications that we made after the General Assembly resolution, as a way to help guide the Youth and Civil Society Alliance in terms of the work we do, and in terms of how we are organizing, coordinating our arguments and support to countries in terms of the the most progressive arguments that we think countries can and should make under international law. And a look at all of these obligations through the lens of intergenerational equity is provided in the Youth Climate Justice Handbook, along with some discussion on, as mentioned, the children's rights, but beyond that as well. And so the idea behind this whole exercise was to ensure that the principle of intergenerational equity, which has been recognized in some domestic jurisdictions, finds a more reinforced, or is cemented in international law as a principle of general international law. It does not enjoy that status at the moment. And so we are at the moment working to ensure that young people and children are included in this second phase of the campaign through a number of ways, and some of them Ben has mentioned. I mentioned the Youth Climate Justice Handbook as a way that argues the principle of intergenerational equity and can really strengthen that position. So we will really have a more solid position for young people to argue their case if we have a strong recognition of the principle of intergenerational equity about present and future generations as well. And so focus on countries that make submissions, or encouraging countries that make submissions around these aspects, or have this focus in their submissions, will be very helpful to include children's voices before the ICJ and in the resulting advisory opinion as well. There is also some work being underway in trying to document witness statements or evidence from people who are at the front lines of the climate crisis, and attaching them as part of country submissions as annexes before the ICJ. So, of course, civil society and individuals, we cannot make submissions directly by ourselves. And so country submissions become the best and most positive way for us to participate in the process. And many countries in the Pacific have indicated that they are interested in attaching evidence or witness statements or as annexes from civil society. And so at the moment, we're working to document the realities of the statements of children and young people who are at the front lines of experiencing the impacts of climate change, and then attaching them as part of country submissions so that these can then complement the submissions made, complement the legal arguments that are made by these countries as well, so that we are together making, as the Attorney General said, the most robust submissions as possible before the ICJ, because these will most definitely be a once-in-a-generational opportunity for us to shape international law to work for us, work for the global South countries and those at the front lines who have been experiencing the impacts of climate change for so long and will continue to suffer if we do not take action now. With partners, the third point I'd like to mention on how we're trying to ensure the inclusion of children and children's voices and young people's voices is with partners in UNICEF and Save the Children. We have been working on running child-led forums in countries across the Pacific, and the idea, and thankfully we've got an extension that we can now work on this a bit more extensively across the region, is to create a declaration on children that can also be attached as an annex to a country submissions to be sent before the ICJ. And the idea again is to provide children with another platform to, along with witness statements, along with testimonies, this idea that declarations that carry the voices of children, that carry the aspirations and opinions of children before the ICJ is also very important. And with our partners, we're working on ensuring this happens. So very grateful for Save the Children and UNICEF for supporting this as well. For us as well, we have had the honor and the opportunity to also be part of some drafting teams supporting governments directly, with internal drafting teams that have been created within some countries that have included young people. And this has been a long ask, and I think a very good model for us as well, in order to ensure young people and children's voices are included. And the most easiest way to do it if they're included in the drafting process of these submissions by countries. And so that is a very positive step, a very progressive way of including children and young people and their voices before the ICJ. And in the future, when we do go into the oral submissions phase, we are also looking at ensuring and supporting young people and children stand before the ICJ, present before the ICJ as part of country delegations as well. And these will be very historic opportunities again for young people and children to speak before the ICJ on matters specifically relating to children and the environment. And lastly, I think just to add on to and something that we were discussing earlier in part of conversations and write-ups as well, is that the second part of the legal question that has been asked of the ICJ is around consequences relating to present future generations, question 2B. It's a question that's relating directly to children and young people, and there can be ways that young people and children can be offered an opportunity to respond to that, and carrying those voices, carrying those opinions and suggestions by young people and children into country submissions would be helpful. And so urging countries to listen to young people and children when specifically responding to these questions would be very helpful. And I reiterate my points around witness statements and the child-led forums as being great ways for articulating these, and for countries to hear these opinions and hear these outputs, and then input them into country submissions in a more progressive manner. All of this is to say that the amount of work that's been underway or that has undergone in supporting Pacific countries by essentially all of the Pacific coming together has been very, very heartening, and has been outright amazing. I think this has been a whole of society support, of all hands on deck approach so far, and I think we're moving in the right direction. And with the extension now that the ICJ has given us for the written submissions, which was due in January, now it's moved to March. There's a lot more chance and opportunity for us to collaborate further and really solidify these arguments so that we can make the most progressive arguments and get the most impactful advisory opinion from the ICJ. Thank you so much.
Thanks a lot, Vishal. Yeah, it's always great to hear from you. And I think you've provided some really good and practical examples, of how to ensure young people and children are heard during this process. The Youth Climate Justice Handbook is a fantastic resource for any organization looking to kind of pursue these ideas. The ICJ is going to hear from a lot of lawyers. So in my opinion, at least an effective legal strategy and, also an advocacy strategy is figuring out how to get youth voices in front of the ICJ as well. So through several the ways that you mentioned, Pacific Island students fighting climate change have been doing testimonials, declaration, even children themselves appearing before the court. So thanks so much for coming in there. Our next question, I'm going to throw it to the AG. As we've mentioned a few times, the government of Vanuatu has really kind of picked up this call that was initially from the Pacific Island students fighting climate change, and then took the issue to the General Assembly. So I was hoping you could talk a little bit about how the voices of young people have influenced Vanuatu throughout this whole ICJ Advisory Opinion process. And how you plan to include children's rights in your own submission. Thank you. Over to you, Attorney General.
Thank you, Ben. Thank you, Vishal, for those comments you made. Yeah, well, let me share some ideas on the question. Firstly, I will share some. I will say something on how the voices of young people have influenced Vanuatu throughout the ICJ process, and secondly, how we plan to include children's rights in our own submission. So on the first one, the voices of young people, how it has influenced Vanuatu throughout the whole ICJ initiative. As you probably know the story, that young people have from the very beginning played a very important role in shaping Vanuatu's position throughout the ICJ process. At first, the idea was shared by law students studying at the University of South Pacific, and then they presented the idea to the Minister for Climate Change sometime in 2019, and then from there, it was a strong bipartisan political support led to Vanuatu's formal engagement in partnership with the youth advocate. Vanuatu collaborated very closely with the Pacific Island students fighting climate change and the youth representative such as the Vanuatu Climate Action Network during the initial diplomatic phase. And this involved actively addressing concerns raised by the younger generation. And Vanuatu continued this strong collaboration with the Pacific Island students fighting climate change at almost every international climate event. And just a couple of weeks ago at the COP28, we were very grateful for their support and collaboration at the ICJAO side event on strategic coordination between SIDS. In the current legal phase, our commitment to incorporating children's rights, intergenerational rights, and the priorities and voices of young people, the focus remains very high in incorporating all that in our submission. For example, we have been working closely with civil society organizations to provide testimonies through their networks. Last month in November, we collaborated with Save the Children in a child-led forum with the aim of incorporating the priorities and voices of our future leaders in the submission process. So yes, we continue to work with civil societies and young people led group to engage them in this second phase as we prepare for our legal submission. And the fact that we have just got another 2 months extension, we're looking forward to continue that collaboration in the extended time we have been given. Now, with respect to how Vanuatu, how we plan to include children's rights in our submissions. In our submission, Vanuatu is emphasizing the violation of child rights by omitting states. And by this, we intend to showcase how the state's actions, breach existing obligations under international law, and particularly obligations that extend beyond the provisions of Paris Agreement. And I mentioned earlier the Convention on the Rights of the Child is giving it customary international law, and it clearly makes it the source of legal obligations for all states. And now this is one reason why the question before ICJ was formulated as it is. It refers to human rights and general international law obligations, to make sure that we can assist the court in understanding that human rights obligations are not voluntary, like what we have under the Paris Agreement, the NDCs under the Paris Agreement. And that is very important. We have to make the court understand that human rights obligations are not voluntary. And also in our submission, we intend to align our arguments along the lines of the General Comment 26 by the Committees on the Rights of the Child. And we assert that all states are accountable for the environmental harm caused by the actions, and of course with implications that reach far beyond the borders. And that is how we intend to align our arguments in line with the General Comment by 26 by the committee. And also the principle of intergenerational equity, for example, that is recognized by committee, underscores that states bear the responsibility for foreseeable environmental threats arising from their acts or omissions. And also states with cumulative historical contribution to emissions have essentially breached these obligations through their conduct, whether their conduct is by actions or omissions that have caused this environmental harm and loss and damage to the children and future generation. The consequences of this under the general international law in relation to state responsibilities are reparation. And in this respect, I would encourage that all states take note of these arguments, and that they should consider making these points part of the submissions. And we believe that it is arguments like this that will lead to an ambitious outcome that will lead to real life practical shifts in future climate negotiations. And in all this, I guess what I'm saying is we need a new approach based concept on polluter pay to protect children's rights and other rights. And the International Court of Justice Advisory Opinion can achieve this if we put our rich and space legal minds together and to fight this, to push this initiative through the ICJ. And having said this, if there are states out there or parties out there who are interested in these arguments and who would like to have more discussion on these areas with us, please reach out to us. You can reach out to Vanuatu and Sophie, our Vanuatu's legal advisor for the Pacific, is on standby. Please reach out to us, to Anne Sophie, and make the connection. We can have the discussions on that and how we can, come up with a lot more robust ambition, because we just don't want an advisory opinion. We want a robust advisory opinion, a progressive one, a one that will have an impact when we go for climate negotiations. So please, having said that, reach out to us. We will be more than happy to continue this discussion. Thank you, Ben.
Thank you, Attorney General. Yes, I think it's as always, is Vanuatu setting an example here that we'd be lucky if more governments followed. A great example of young people and a wise government working together to amplify each other's voices and impact in this process. But also, as you were speaking about at the end, the strategic implications of including arguments related to children's rights and international intergenerational equity that can lead to an ambitious outcome. Sorry, Christmas music just came on in my office. I don't know if you can hear that, but so sorry if there's a bit of background noise. I will now bring in Gabby and SPC. I think, as we all know, SPC has played a leading role during this whole process in convening and supporting Pacific countries. I was just hoping you could talk a bit about, the role of SPC and the impact of Pacific countries working together during this whole process. Thanks, Gabby. Over to you.
Thanks, Ben. Hi, everyone. Good afternoon. And thanks to all the panelists so far. Yeah, of course, happy to speak briefly. I'm conscious of time, so I will keep it brief. But certainly just touching on the kind of contributions that SPC has made alongside everyone else in the room today. The main ones here, kind of in terms of what has been occurred to date, is the two ICJ rights shops, one which was held in July this year and one in October, which brought together, kind of provided an opportunity for country teams to come together, look at the latest scientific evidence and legal expertise to help in that drafting process and help countries as they start to draft their submissions for that advisory opinion. And then also the technical expertise and support that's been provided alongside requests for expert kind of reports. So looking at when Pacific Island countries and territories are needing some of the evidence for their written submissions, which will go as kind of annexed reports alongside their submissions to the ICJ. And just on that, if you do wish for SPC's support in that process, please do get your kind of formal requests into us as soon as possible so that we're able to provide that support to you and your team. But what I really wanted to focus on was the future support. So both in terms of the written submission as that, especially now that we have that extension, and also the oral submissions. And, with the focus of today being on children and youth, and not just the rights and the international conventions relevant to them, but also the ensuring the inclusion of their voice, as we've heard from some already today in the submissions. So certainly what we're hoping SPC can also contribute is its own written submission, and where we're hoping to really draw on our probably the Pacific Youth Congress, but also our NYCs, the National Youth Councils, to really draw on that expertise and youth voice to answer question 2B directly around the impacts on future generations. So I think when we look at this broadly, this powerful and inspiring movement, and as we already heard from Vishal, emerged from the hearts and minds of young Pacific Island activists to combat the kind of pressing issues of climate change. So stemming from, youth taking important actions in the hope of securing a sustainable future. So I think, for us, it's only fitting that their voice, their passion and their creativity is really harnessed to further progress these discussions in the hope for meaningful change. And we're more than happy to kind of support countries in what that looks like if they need support in terms of pairing up with with those representatives, the youth representatives and youth voices in country alongside others today. So looking at the application of a child rights-based approach to the environment does require, as we've already heard, full consideration of children's rights under the CRC and the optional protocols, and particularly Article 12, when we're talking about the right to be heard, the right to have a voice, and the right to the opportunity to kind of contribute to judicial processes as well. I think through General Comment 26, we've also seen recognition of that intergenerational equity and the importance of that by the committee in order to consider the interests of future generations. And I think that's also a principle that we can look at further solidifying to ensure future generations' needs are factored into climate responsive action. So, we've already heard from some today that states bear that responsibility for the foreseeable environment-related threats arising as a result of their actions or their omissions of action. And one of the factors in that is that the full implications of that aren't necessarily going to be seen for years or perhaps even decades. So until those future generations are moving in. So based on that available science, I think the Pacific is facing some of the worst outcomes when it comes to the climate crisis, and the threat to existence, the threat to livelihoods exists to a higher degree for our Pacific youth. So we would love to see youth voice genuinely and meaningfully incorporated into this process, particularly as future custodians of the Blue Pacific. And I think it allows for that potential of a greater, more transparent and more collaborative process, but also really strengthens this process overall the more that we're able to draw on the expertise and the inputs of youth throughout kind of across the Pacific. I think we, even in frameworks like the Pacific Youth Development Framework, we see the recognition of the value of youth voice, but also we see recognition within that framework and the consultations that led to it of the challenge that can sometimes exist in Pacific contexts and cultures for youth to contribute, particularly in some of these more formal spaces. So I think we're really keen to, again, impress the importance of this, but also support if there is a desire and a need to kind of draw on that expertise or create those linkages so that we can really harness the strength of all different parties as we move through this process. I think this is an opportunity to really kind of harness combined strengths. So we have the knowledge and skills of the legal professionals. We have the knowledge and skills of our evidence that's building on the science and the impacts that we're seeing from climate change, particularly in the Pacific. And then we have that creativity and knowledge and real kind of passion from the youth, which allows us to generate creative legal arguments that push beyond the status quo, as we've already seen from where we are today with this process. So yeah, again, I just implore you to ensure that youth voice is meaningfully captured in your written submissions. I think that there's a range of ways to do this. We've already heard about the Youth Climate Justice Handbook, which is a great resource compiling the kind of legal arguments addressing intergenerational equity, human rights, the interests of Pacific youth. We've talked a little about the youth and child forums that have been offered and the witness statements that can be provided as annexes. I think for us, there's also that consideration of really directly allowing the contribution of youth to answer question 2B when in the written submissions. So that's certainly the approach that SPC will take if we're able to submit. And we really encourage other countries to consider that in their submissions as well. And then I would say, as a very bare minimum, to ensure dissemination to relevant kind of stakeholders in or consultation in that way in a kind of multiple languages formats in a age appropriate and accessible format if possible. Yeah, I think Pacific countries working together, as we kind of touched on with the question, especially under the transformative power and example of Pacific youth, will bring the forceful and necessary change we need to see, especially at these highest levels like the ICJ. And SPC is certainly committed to keeping youth at the centre of its assistance to the region. So please don't hesitate to reach out if you're wanting support in that way as well. Thanks, Ben.
Thanks. Yeah, thanks so much, Gabby. Yeah, I think beyond all of the, extensive support that SPC has provided, to states in this process, it's great to hear that, you've been accepted to make a submission in your own right, and that you'll be using some of the arguments that we've been discussing. I really like how you phrase it, actually, hearing from young people's voice, passion, and creativity to inform your arguments. I might steal that from you. And it's great. Yeah, I think completely agree. Pacific countries and others coming together and combining strengths is, the best way to ensure a positive result. So thanks so much. We have one more panelist. We have a few minutes left. John, very sorry. I've been in this position before at the last Right Shop, speaking as the last person at like 4:30. So sorry about the timing. But I did want to give you a few minutes to talk here. So Professor John Tobin, as we've heard before, the CRC is the most widely ratified convention in the world. I just wanted to ask you a bit about your work in interpreting the convention and how it can be used to promote children's rights kind of in this era of worsening climate change. I think both with regards to the specific ICJ process we've been discussing, but also beyond. So over to you, Professor. Thanks.
Yeah, thanks, Ben. I'm conscious of time, so I'll try and make some very edited and hopefully relevant comments. Just obviously first like to acknowledge I too am meeting to you or coming to you today from the lands of the Wurundjeri people. In the backdrop, you'll see Local Creek, which is known as Dirban Creek, and the Warring language as well. So what can I say in about 3 minutes or less that is of relevance here? I suppose the first thing is that when we're thinking about children in this context, we're thinking about the convention, we're thinking about the idea of a rights-based approach. And that has, I think, two really important ingredients. One is that it identifies the process by which we go about addressing climate change. And the second part, of course, is it sets the standards for which we actually seek to achieve as well. So I think that's come out pretty clearly in the conversation to date as well. In terms just of the process, again, I want to just emphasize everyone's been talking about the importance of children's voices, but I also want to highlight that it's both social, political, and legal. So when we talk about getting young people to be involved in either making submissions to the court or submissions as part of the general comment itself, I think 16,000 plus, that has a significant impact on the children in terms of their own sense of self, as a sense of the social and political narrative around climate change and the role of children, but also as a legal impact as well. So we're sort of looking at a number of levels. So this whole process, I think, isn't just about the ICJ Advisory Opinion, it's about what's happening domestically as well, and the models we're creating both in terms of collaboration, which is taking place in the Pacific, but also what it might show countries like my own, where we really haven't in any way, I think, done what's been happening with leadership like the government of Vanuatu around really encouraging, supporting people to express their views and then amplifying those on the international stage as well. So that process is critical. It's got a legal foundation, and in terms of thinking about the ICJ Advisory Opinion, the hope would be, and I think this is really important, is that we'll see the court actually address Article 12 in a substantive sense and give directions to states about what that requires in terms of the measures they adopt both locally, regionally, and globally when it comes to climate change. That hasn't really been done, I think, at that level by the court. And I think this is a really important opportunity to do so. The reality is that children's rights is often infantilized in the world of international law, not taken seriously. And so the real hope is that the submissions being generated by so many parties, as we're speaking about today, will generate some really significant legal arguments that will compel and persuade the court to adopt those, okay? Just on that point too, I think we need to highlight the reality that sometimes the committee isn't as robust in its defensive principles as it needs to be in terms of what's before the court. So even take the principle of international equity. There's one paragraph in the general comment that will not be enough to persuade the ICJ to embrace that idea. We need to be offering more in terms of arguments, I think, to ensure the court distills with clarity what that actually looks like and means as well. So I just want to throw that out there just to be mindful that sometimes I've read in many jurisdictions around the world at regional level, particularly in domestic, that sometimes the work of human rights bodies aren't always adopted in the ways we'd like them to be as well. So to go back to the attorney's point at the very beginning, we want to have really robust arguments, absolutely, but really, I think, persuasive ones as well out of a legal foundation. Just quickly running through them as well, beyond the issue of Article 12 in the process, clearly the rights-based approach articulates the standards we're talking about when it comes to what we're seeking to demand of states when they respond to climate change. A few key points to make before I sort of wrap up. Article 2 is about non-discrimination, but importantly, that's really about targeted measures. That's significant both for individual states, but also for the obligation of international cooperation. So within, again, the context of Pacific Island states, the argument we'll be making, I think, is that each individual state has to take measures to address the needs of children, rather, as a consequence of climate change within their own jurisdiction, but also we want to be putting pressure on states as an international community of states to take targeted measures to address the special needs and rights of young people as they arise as well. And that's linked again to the principle of common but different responsibilities. But I do think it's actually a core part of what a rights-based approach requires. And I think there's really some big scope to make that argument and push the ICJ to think about the idea of targeted measures as well when it comes to responding to climate change. Similarly, the best interest principle, I think, needs to be given much more airtime in any conversation around climate change and children. I think this has a really important role to play in actually giving some foundation to what the principle of international equity looks like. That requires, again, some robust legal analysis to expand and develop that principle. But this is not about saying that kids' rights necessarily trump competing considerations, but they're elevated to a point where historically they've been omitted from many conversations around what happens when it comes to how we address climate change as well. So I think that's a really significant principle that has a lot of potential to be very flexible and adaptable in perhaps, I suppose, addressing and providing those robust arguments that the attorney and other commentators have mentioned today as well. Just skipping ahead, I think what we want to see the ICJ do, of course, is really identify both the scope of states' obligations within their own territory, those respect, protect, fulfill obligations that Nastasia and Phoebe outlined in detail. I think there's a growing consensus now amongst international and regional human rights bodies that, the arguments that have been outlined are fairly persuasive around the burden imposed on states. Where I think the gap remains and where the challenge is, I think, is around this obligation of international collaboration and cooperation. So, that's, I think, a really important thing to be thinking about in terms of submissions being made, particularly from Pacific Island states. What can we reasonably demand of other states in terms of what they might provide in terms of assistance to prevent, but also adaptation measures as well, and remedial measures where they arise too. So I think there's some really significant legal analysis that needs to be done there, because historically, states have been reluctant to accept the substantive content of any obligation around cooperation and collaboration. Yes, we've got really direct arguments made around the obligations of states and transboundary harm. That only takes you so far as well. So we need to be thinking about how can we make those arguments it's more persuasive to convince the court to actually give some robust content to that particular obligation as well. So, just wrapping up, I think the hope from my perspective, an academic who works in this space for a long period of time and has seen human children's rights very marginalised, is to really see the ICJ identify their significance, not just in a tokenistic way, but in a legal sense. There's an obligation, consider Article 12, to assure to each child the right to express those views, but also to give them due weight. And that's, I think, significant again. So we're not just having these kids present, make submissions, attach appendices to submissions. We're saying we're demanding that states consider those submissions in a meaningful, substantive way, and we're demanding the ICJ ask of states that they give them due weight, and when they don't act in accordance with children's views, they can justify that failure to act as well. So I think there's a really strong onus and obligation on states to be taking the obligations under the CRC seriously, as they historically have not. But the idea would be that the ICJ would actually clarify both the procedural elements that flow from Article 12, but also then really both clarify and affirm the scope in the highest possible manner, the obligations imposed on states with respect to actions within territory, but also transboundary impact, which we're, I think, having more consensus around now as well. Then finally, that last point around international cooperation, what the obligations might actually look like and require, because without that collaboration, we won't see the transformation as well. And the final point I'd like to make as well is that this exercise, for me, from my perspective, is really significant in some ways, irrespective of the ICJ's decision, because it's providing a galvanizing effect amongst states within the Pacific, which will hopefully prod states like my own to actually start taking this matter seriously, both domestically with respect to young people, then also internationally in terms of how they might respond to assist other states within the area as well. So I'll finish there because I'm conscious of time, but I think it's just a wonderful collaboration and initiative to see so many people working, both governments, NGOs, international organisations. Special thanks to my colleagues at CAUSE as well for getting together the brief in a pretty remarkable period of time. So I'll end it there, and I think everyone's be happy to log off, but I'll leave it back to you, Ben. Any final comments or observations as well?
Thank you, Professor Tobin. Yeah, really interesting. We could have wish we had more time, but as you said, we're running out. I think if there's any questions, anybody can also write to us afterwards. As you've heard, there's quite a few offers of support, from the government of Vanuatu itself, from SPC, from CORS, and I would add UNICEF to that list. So we're here to support any country in the Pacific also throughout this process, particularly around children's rights and all of the issues we've been discussing. Thank you so much to the Attorney General, to SPC, to CORS, to Vishal and Pacific Island students fighting climate change, to Professor Tobin for joining today. I think it's been a really interesting session, and we'll be disseminating the legal briefing and also the recording of this webinar. So hopefully with the extension that several people have mentioned, we also have the time to really flesh this out in the process over the next few months. So thank you to everybody. Yeah, really appreciate it. Wishing everyone a happy holidays and happy new year. Thanks a lot.
Well done. Thank you. Well done, everyone.
Thank you, everyone.
Thank you very much.
Thank you.